Great. Good afternoon to the Microsoft Teams universe, and thank you very much for joining us this afternoon for a very short webinar on some of the developments in competition law enforcement in the face of the COVID-19 pandemic. We are obviously extremely grateful for those of you who've joined us. We're very acutely aware that under the current circumstances, time is an absolute premium, whether it's work pressure and the usual hothouse that requires, family obligations, or your Netflix queue. We know that we are competing heavily for your time, so really do appreciate that. If I could coin a competition law economics term, it's all really about allocation of scarce resources, and I do hope that having allocated 45 minutes or so to us today will prove to be efficient for you and for us. I'm just going to make some quick introductions before we start. My name is Chris Charter. I am the practice head for competition law at Cliff Decker Hoffmeyer. It's an easy job when I consider the quality of my colleagues and their level of expertise, two of whom are going to be assisting today with the presentation. Susan Mayer is a partner in our Cape Town practice, and Albert Okama is a partner up in Johannesburg, and they will also be giving some insights into some of the regulations that the authority and the Ministry of Economic Development and Competition has passed recently. So before I start, I'm just trying to issue the usual health warning for these type of webinars. What we're intending to do today is give you a bird's eye view of some of the key developments which really do fall within a spectrum around the world currently of regulatory best practice during a time of crisis. Needless to say, although you're welcome to post questions and we'll do our best to cover those in the time allowed, please don't treat this as specific legal advice. Competition law in particular is an area where the facts really do matter. It's very difficult to give advice in a vacuum, and anybody who's got any particularly seething problems, we'd welcome you getting in touch, and obviously we can get into the specific facts of that to make sure the advice that we do end up giving is correct and on all fours with the facts. So there are about 100 or so competition regulators throughout the world, and no less than half have already published a way of doing business which is fundamentally different from what it was a month and a half ago. And it's in really two areas where these differences are coming to the fore. The first is in merger control, where obviously capacity constraints and other challenges have an impact on any regulator's ability to assess, investigate, and eventually clear mergers. The other key area where competition law is adapting at lightning speed is in terms of collaboration between competitors and others in the value chain, which ordinarily is an absolute anathema to competition lawyers and to competition regulators, and a need has been perceived to allow for some relaxation. And this really is something where South Africa falls on a spectrum with other regulators around the world, and it's worth bearing in mind these new rules, albeit temporary. So just in terms of the housekeeping, in terms of what we're going to talk about for the next little while, I am going to discuss a little bit the current merger control paradigm with the Commission. We've had discussions with the head of mergers and acquisitions at the Commission, and she has given us some key insights into the challenges they're facing and how they plan to traverse those. I'll then talk a little bit about interim measures regarding pricing throughout the supply chain, which is something that the competition authorities is particularly preoccupied with, in order to ensure that prices don't rise unduly under the current circumstances. And then Susan and Albert are going to take us through some of the key block exemptions, which have been issued in order to specifically allow for some wiggle room, as it were, in specific industries which are deemed to be particularly important, that they function effectively and efficiently during the crisis. And then we will close off with some closing thoughts on what a post-COVID-19 competition regulatory world might look like. And then, if time allows, we'll look at some of the questions that might have been posted. So then, without further ado, let me just start with the issue of merger control. Obviously, a big factor for any regulator, and certainly for M&A activity in this country, very often, nothing happens unless and until you have got your approval from the regulators. So that remains the case. The big challenge with merger investigations during a lockdown situation is that, just like all of us, the Commission's investigators are also sitting at home, also wrestling with the usual challenges with connectivity, perhaps even motivation to some extent, and the difficulties in keeping in touch in real time with their colleagues. So really, what we've been admonished by the Commission is that although their merger control team is fully up and running, all working remotely and motivated, we should expect a certain amount of delays. Now, some regulators around the world have in fact shut down operations completely and said, unless you've got a COVID-19 related emergency, we won't be looking at rendering any services. A country like Botswana has effectively broadcast that. Our authorities are open for business, but they've indicated that there are certain challenges, and those challenges really are based not so much on capacity. Those who are in the M&A space will know that the sort of trajectory of merger activity has declined along with the sort of economic downturn. So the Commission hasn't been all that busy of late, and we're told that as of last week they only had 24 merger cases open, which is exceedingly low, and only 2 new filings since lockdown. So certainly the issue with them is not a capacity constraint. The problem is really in terms of conducting a investigation which requires more than a desktop analysis. So the feedback from the Commission is that if your merger involves any kind of a competitive overlap, which will require feedback from market participants like competitors and customers and suppliers, or if it raises any potential public interest issues, in particular a loss of jobs, then they're going to find it very difficult to stick to their preferred timelines. And that's really because they anticipate that they can send questionnaires out into the market, but people are most likely going to be a little bit preoccupied over the next while, and therefore they don't expect those things to be responded to particularly quickly, which is going to cause some delay. So the message from the Competition Commission is that they do have capacity. So-called phase 1 mergers, those which raise no competition or public interest concerns, we can expect to be dealt with in the ordinary course, and probably with due haste. They will particularly prioritize, for obvious reasons, failing firms, and I'll say a little bit more about that towards the end of the webinar in terms of where that might be headed. We can obviously anticipate, I think, a spate of takeovers of companies in distress, and the Commission is looking to gear up for those. But if your transaction is a complicated one, if it involves overlaps, if it involves the acquisition of a competitor or vertical integration, or if indeed there are any job losses envisaged, then it's going to take a lot longer. And the message from the Commission is you should expect at least 120 days for any large merger that raises some or other concerns, however minor they may be, and that we should be looking to sort of towards the statutory maximum time period for intermediate mergers, which is 60 business days. So that really has a pretty important implication for any deals currently in the pipeline, particularly in terms of determining your long stop dates, because it becomes very difficult now to predict any kind of early date for merger approval, and people would do well to build in a lot of extra time in order to get your merger approved. So that really is the feedback from the Commission. They initially came out to say, as did some other regulators around the world, particularly in Western Europe, who said, look, really, please don't notify your merger if it's possible not to. That's obviously a pro non scripto concept, because everybody who's doing a deal needs to notify their merger. So the Commission has backtracked from their initial suggestion that people just be discouraged from filing mergers. They said, by all means, file your mergers, but do build in the fact there will be some delay. 2 other issues which are going to provide some challenges in putting filings together is going to be notification of employees in particular, particularly trade unions. Trade unions, as you may be aware, are statutorily required to be notified of any merger, and if that happens, they do have a statutory right to become involved. And the Commission typically follows up with trade unions to make sure they have no concerns. The difficulty now, of course, is trade unions are unlikely to respond to those kind of inquiries. And there's a particular onus on merging parties to try and make sure that that merger notice is received and acknowledged by trade unions in particular, and that if you're notifying employees through some other measure, that it's very clear to the Commission that those employees have been notified, because that really is going to be quite a big stumbling block. And finally, in some cases, particularly for mergers which are in the pipeline where statutory time periods are expiring and would require an extension, the Commission is a little bit hard pressed on that. So what they have done is they have upfront for those mergers, and there would only be a handful of them which have been which would have had an expiry of the initial statutory period within the lockdown period. They asked for 2 extensions in a row up front, and the reason they did that is because the process to apply for an extension, if it's not granted, is to go on affidavit with the tribunal. It's a statutory requirement, and because of the difficulty of getting affidavits executed during this period, they've been proactive and requested 2 extra extensions, which is a little bit unusual, and I think gave some of us a bit of a fright. But the reason for that is quite clear. So that's really where we are on merger control. I'll very briefly just indicate that what I think a lot of people are anticipating is that following the fallout from the lockdown and the health crisis, it is likely that a lot of businesses will go into some distress. There are obviously going to be opportunities for takeovers. A lot of debt will be looking to be converted into equity. Those who have some private equity funds available and have an appetite to take on rescue animals will no doubt be looking to make some key acquisitions, and a lot of that will have to be fast and loose. And one concern has always been the speed with which the Commission can investigate and approve those transactions. So the Commission is very well aware of that. They have got a specific team on to identify those, and the indications from the Commission is that they will do their best to approve those as quickly as possible. One thought that we had floated with the Commission, and they are taking it back to their executive committee, is the possibility of extending the practice note that they issued in terms of risk mitigation financial transactions to other forms of acquisition of a failing firm. Just very briefly, the practice note provides that registered banks and state-owned financial institutions who are not banks, but only those 2, banks and state-owned financial institutions, who have taken security over the assets or shares in a company and realize that security in order to protect their exposure from a funding perspective, even if realizing that security, for instance, a pledge or pref shares, if that allows them to take control of that business, the practice note provides that they won't need to notify that for a period of 24 months, provided that within that 24-month period, they either sell that on in a notifiable transaction, or they notify and achieve clearance for that. So there is some appetite from the Commission to explore whether or not they might be able to be inclined to extend that practice note to cover kind of debt to equity transactions or rescue transactions, which will perhaps allow those transactions to close, provided that notification is done within a certain amount of time thereafter. It would be a temporary measure, but one which they are exploring, and we certainly encourage them to do that. So that covers merger control. I will say we're in good company in terms of trying to address these challenges, and there are regulators all over the world who have issued similar warnings about timing around these parts. I've already mentioned that Botswana has ostensibly suspended all its services since April the 2nd. They're on a 3-week lockdown due to expire soon. With luck, the Namibian authority is still operating. It has indicated that it's taking email submissions, which is new for Namibia, which is a good thing. Kenya is open for business. It is also issued some notice that it is going to really focus on what it calls unconscionable conduct, in particular price rises. And Zimbabwe has scaled down its operations, but it's still accepting merge notifications. One thing worth noting in Zimbabwe is that while the country is in lockdown and a national disaster is declared, they've in fact converted some of their anti-competitive conduct provisions, which are abuse of dominance, into per se prohibited conduct. So things like tying, excessive pricing, and bundling are, at least for the period under lockdown, considered to be per se prohibited, which really is a warning for anybody doing business in Zimbabwe not to use the opportunities to exploit consumers. So maybe that then takes us as a good segue into the next subject that we wanted to explore, which is pricing in a time of COVID-19. Again, all around the world, there are regulators are wrestling with exactly the same situation, particularly for key goods, basic foodstuffs, cleaning products, and those related to healthcare. There's been a surge in demand, and that will lead inevitably to undersupply. That undersupply is obviously exacerbated by the fact that a lot of businesses are not operating at full capacity due to the health crisis. And so there is a big problem around the world with allocating those resources. Now, ordinarily speaking, what one does when demand vastly outstrips supply, the natural market response is to increase prices. And the economic rationale for that is what you're doing is you are pricing to the demand curve. In other words, those who can afford to pay the higher prices will pay the higher prices. Other people will buy fewer products, and in that way, the supply crunch is regulated through the market. Now, there's growing recognition that in a time of this kind of pervasive healthcare crisis, that is simply not feasible to allow the market to regulate in that way, because that will really prevent key goods and services from finding its way to the areas where it's perhaps most needed and where people are most vulnerable. So most regulators around the world have in fact taken measures on board to certainly prioritize allegations of any kind of exploitative pricing practice, and ours is no different. So on the 19th of March, the Commission very proactively published the first of a number of regulations, the first ones which deal more broadly with pricing. It lists certain goods or services, in particular those which apply to which are particular importance during this time. There are very broad categories, so it potentially captures quite a lot of products and services. The list includes basic food and consumer items, emergency products or services, medical hygiene supplies, and emergency cleanup products. So if we start with basic food, that covers a great deal of products. They've also provided a slightly exploded list of those which they consider particularly important, and it ranges from, not surprisingly, toilet paper and hand sanitizer and facial masks and disinfectants, all the way through to basic foodstuffs like rice, maize meal, pasta, sugar, long life milk, and canned and frozen meat, chicken or fish. So those are the products that we're concerned about. And what they've done is they have sought to try and create an environment where two things can happen. One is, and this is in line with best practice around the world currently, is to promote concerted conduct between suppliers and customers at the wholesale level, and suppliers amongst themselves, to try and alleviate the effects of the national disaster. And equally importantly, they're seeking to protect consumers from what the regulations refer to as unconscionable, unfair, unjust, or improper conduct, particularly with regard to pricing. So that's what they're trying to do, and they're doing it really in terms of two mechanisms. The first is to address on a temporary basis the question of excessive pricing. Now, very interestingly, in only February of this year, certain amendments of the Competition Act actually came into force, and one of those was to change and codify the way in which excessive pricing is assessed. Excessive pricing is something that is prohibited for a dominant firm to do, And the new provision provides that an excessive price is one where the price is higher than a competitive price, and the difference between the price charged and the competitive price is considered to be unreasonable. Now, simple enough. So an excessive price is one which is unreasonably high compared to a notional competitive price. But obviously, it's very difficult in real life to prove what is the competitive price in the first instance. The courts can decide whether the difference is unreasonable, but trying to establish the competitive price is notoriously difficult. So the Act does set out certain factors, but one of the factors that it sets out is regulations that the minister might publish, which will then set out the criteria that the minister believes would be relevant to determining an excessive price. And the minister has taken advantage of that brand new provision to issue regulations. And he's done so, I think in a way which is admirably circumspect. He's not at this stage sought to reserve too much power for himself, or indeed to undo basic competitional principles. What he's done is he said that during the time of national disaster, and this is a regulation, so it is time bound. It's not a new rule that is going to apply for all time. While the national disaster is in effect, any material increase in the price for certain goods or services would need to be monitored quite carefully. And essentially, there are three tests that are applied when one is considering the pricing of a dominant firm for those key goods or services that I mentioned. And those are, first of all, is the price increase material? And if it is material, then it needs to be shown that that price increase is either it corresponds with or is equivalent to the cost increase. So if your price increases materially, you need to show as a dominant firm that is just in response to a material cost increase, which is commensurate with the increase in price. If it's not, then your pricing is most likely going to be considered excessive. The third test is an alternative test, and it's looking at your net margin. So it looks at the net margin or markup, and it referenced that against a benchmark margin, which the regulations provide for being the 3 months leading up to the 1st of March. So essentially that's December, January, and February. And you can already see that using that as a benchmark is going to create problems on two fronts. The first is a lot of those basic foodstuffs are on promotion over December, January, and February. So the benchmark price is not necessarily going to be a good indication of what the competitive price actually should be in ordinary times. So that is something to bear in mind. Already, though, the Commission has indicated that it is alive to that issue, and it is engaging with certain suppliers where that seems to be the case. The other difficulty is that some of these key products and services might be new. A lot of factories have reconfigured their production lines to produce, for instance, masks. And of course, those won't have a 3-month price history in order to benchmark. So there are other mechanisms the regulation makes available. One of those is provision for maximum price setting by the Minister of Health in conjunction with the Minister of Trade and Industry and Competition to actually set prices for medical goods and services which are related to COVID-19, in particular test, prevention, and treatment products. So that is really where the pricing issue comes in. Just very briefly before I wrap up this section, there are also specific obligations placed on suppliers. So this is with regard to the making available goods or services. So you have an obligation on the one hand not to charge excessively. There is a new benchmark for what is an excessive price during the national disaster, and that is one area where the Commission is focusing its enforcement efforts. The other area that the regulations attempt to alleviate some of the challenges under the health crisis is to place an obligation on suppliers to develop reasonable measures to ensure the equitable distribution of goods or of key goods or services on the one hand, and also to maintain adequate stocks. And what this really translates into is an obligation to limit the number of items that are sold to consumers or customers on the one hand, and on the other hand to try and work to make sure that goods or services are made available sort of throughout the value chain and supply chain in the most equitable possible manner. And that may require a certain amount of coordination, and dare we say it, even market division between producers who may require to ensure that they are kept, that distribution is effective, and that one doesn't only distribute into the low-hanging fruit, but also looks to make sure that key products and services are available throughout the country and where they are most desperately needed. So those really are the two current key changes in what one's obligations are, and they are, fundamentally at odds with some existing principles of competition law and economics, in particular the way in which goods are usually allocated when they are scarce. There really is now a call on suppliers to do all they can do to make sure that you perhaps behave in a way which is not altogether economically rational, but is in the national and social interest. My parting shot on this is just to take note of the extent to which the Commission and the Tribunal are working to fast-track enforcement. So particularly on excessive pricing, those who've been familiar with cases in the past know that excessive pricing cases in particular take years of investigation and yet more years to get to trial. What the latest regulations have put in place is a frighteningly quick procedure to bring allegations of excessive pricing to the tribunal, where ordinarily there would be a referral and then 20 business days in order to answer. Now the 20 business days has been reduced to 72 hours. The reply comes within 24 hours as opposed to 15 business days, and then a hearing is set down for 48 hours later. And within that period, the parties are required to provide a joint statement of issues, which will assist the tribunal in determining whether it requires evidence or not. And in certain circumstances, it can make decisions without even hearing evidence. So really, we've gone from a period of probably several years to potentially as little as 8 days in order to prosecute. So that certainly is a warning to those who are sailing pretty close to the wind here that there is massive will to enforce. And ultimately, the most pragmatic advice that we could give is, if you're a dominant firm producing or supplying some of these core goods or services, think twice before you raise your price over this period, because it is going to be a red rag to a bull, and certainly you might find yourself on the wrong side of a narrative, if nothing else. So do give some thought to whether or not you should increase prices at this point. I will pause there and hand over, if I may, to Susan Meyer, who is going to take us through some of the specific block exemptions that have been put in place in the healthcare space. Susan has got a tremendous amount of experience in competition healthcare matters, so I know that she may have some useful insights to give. Susan.
Thanks very much, Chris. And thank you everybody this afternoon. As Chris mentioned, I'll be discussing two block exemptions, which were both introduced pursuant to the declaration of the National State of Disaster, which gives the health sector and the hotel industry greater flexibility in dealing with South Africa's response to the COVID-19 pandemic by effectively exempting certain role players from certain aspects of the Competition Act. So what this means in layman's terms is that conduct that would ordinarily be caught by Section 4 of the Competition Act, now this is the section that deals with cartel conduct and other anti-competitive agreements between actual and potential competitors, as well as Section 5 of the Competition Act, which concerns agreements between suppliers and customers, will now be temporarily exempt for the duration of the state of the disaster, allowing these firms to cooperate in certain ways without falling foul of the Competition Act. So the block exemptions, which I will be discussing, are really the opposite of the excessive pricing rules that Chris dealt with, insofar as those seek to enhance the application of competition law, whereas these regulations actually exempt certain actions from competition law. I think at the outset it's worth noting that the exemptions are only from certain provisions of the Competition Act, namely Sections 4 and Section 5. So this means that the other provisions of the Act will still apply. So there may well be an example of conduct that's exempted from, for example, price fixing provisions, but at the same time could still be found to be an excessive price by a dominant firm. And also very importantly, both exemptions make it clear that the exempted conduct must be solely for the purpose of promoting coordination in order to respond to the COVID-19 national disaster. So in other words, it must always be checked that any concerted action taken in terms of these exemptions can be objectively justified as fitting this narrow purpose. Healthcare and hotel sector participants will need to be very wary that they do not engage in conduct that goes beyond the strict scope of the regulations, as we could then end up falling foul of the Competition Act despite having good intentions. I think in some cases this might actually mean having to navigate a very narrow path of healthy cooperation and meeting the purpose of the exemptions, but also carefully avoiding that the cooperation doesn't slide into a form of illegal collusion. So turning firstly now to the block exemption for the healthcare sector. As we're all aware, the state of national disaster was declared on the 15th of March, and only 4 days later, on the 19th of March, the minister managed to gazette this exemption, which I think is something that must be really applauded, because it's extremely swift action, and it's also an unprecedented block exemption. We've never seen one like this in South Africa before. So at the outset, I spoke to the requirement of meeting the sole purpose of responding to the COVID-19 crisis. That's something that has to be borne in mind the whole time. There are also two other very important caveats to take note of. Firstly, the healthcare block exemption only applies if the relevant agreement or practice in respect of which an exemption is sought is undertaken firstly at the request of, and secondly in coordination with, the Department of Health or the Department of Trade, Industry and Competition. Also, any exempted collaboration can be subject to conditions imposed by either of those departments. And then secondly, any communication or agreement on prices whatsoever between healthcare companies must be specifically and expressly authorized by the relevant ministers. So this exemption is not a signal to competitors that we're going back to the days of collective bargaining on prices. Who does the healthcare exemption apply to? It's very wide in its application, in the sense that it covers 7 different role players. We've got hospitals and healthcare facilities, medical suppliers, medical specialists and radiologists, pathologists and laboratories, pharmacies, manufacturers and suppliers of medical and hygiene supplies, as well as healthcare funders. And healthcare funders would cover the whole spectrum, so medical aid schemes, administrators, managed care organizations, and healthcare insurers. And what exactly is exempt? So what's included is agreements and practices among each of these 7 healthcare sector participants that meet the purpose of the regulations, in other words, responding to COVID-19 crisis. And then they also need to meet specific criteria pertaining to each role player. Now, these requirements are very detailed and they do vary depending on the particular participant, you know, whether you're a hospital or a pharmacy or which role player you are. So I'm not going to repeat all of them verbatim, but just generally to explain what the exemption is trying to achieve at a high level. There are certain common themes that we pick up which help us understand what the exemption is trying to achieve. So any communications on capacity and utilization, so communications that would allow for the best use of hospital beds, ICU wards, isolation facilities, the allocation of patients, types of medical services, nurses and doctors between hospitals, so in other words, to allow for the sharing of critical resources. Then the collective procurement of inputs needed for testing and treatment. This is actually very important because it removes any legal impediment to coordinating on procurement. The standardization of quality of care protocols, and even coordination on the distribution and sharing of supplies, so medical and hygiene supplies. And this will obviously help to ensure that there is adequate supply. The regulations also open the door for agreements to support the public sector. They say that the private sector and the Department of Health can agree to make additional capacity available to the public sector and also to help ensuring the public sector has adequate medical supplies. The regulations also allow for cost reduction measures. So this will be any coordination amongst healthcare role players with the aim of reducing costs. And again, for the avoidance of any doubt, because this will deal with pricing, the specific authorization of the relevant departments will be required for this type of action. And then just practically, it's not quite clear how the exemption will be applied in practice yet. But I think what we do know is that the Department of Trade, Industry and Competition or the Department of Health will have to be central to any process, because one has to request one has to get them to request the coordination and also oversee it effectively. So I think on the one hand, this envisaged role of government is a good thing because it provides an additional safeguard in legitimizing the conduct in case parties are not certain whether their conduct falls within the exemption or not. But what we just hope to see is that there will be a very practical process, because obviously when doctors and role players are on the ground and acting in a crisis, they're going to need some very practical, swift emergency protocol. They don't want to have to be bogged down in some kind of bureaucracy in order to get the exemption they need. Then moving on to the block exemption for the hotel industry. The aim of this exemption is also linked to healthcare insofar as it's to allow government to identify quarantine zones for those affected by COVID-19 and to ensure that those that are quarantined have adequate facilities. Now, when I first read this exemption, I pictured a typical hotel. It's actually quite important to understand that the definition is far wider than that, and it includes all forms of business that provide short-term accommodation and other services to the public. So what is exempt here? We're talking about any agreements or practices in the hotel industry which are undertaken at the request of and in coordination with the Department of Health and the Department of Tourism for the sole purpose of responding to the COVID-19 crisis. These agreements and practices must encompass identifying and providing appropriate facilities. And again, if there's any discussions on reducing costs, then those would need specific approval by the relevant department. So just a few thoughts in conclusion. I think given the anticipated strain for the healthcare system, as well as the potential harm if this COVID-19 is not successfully contained, these efforts by government to bolster our ability to deal with the pandemic must really be applauded. I think it's reassuring to see that competition law will not unreasonably stand in the way of legitimate measures to respond to the crisis. Impressively, both exemptions expressly state that it's understood that the management of this pandemic is not static, and therefore to the extent that role players in the healthcare sector and the hotel industry want to seek amendments or additional types of agreements that should be exempted, they can request an expansion of the relevant regulations. Then it's also important, I think, to understand that both exemptions will only remain in force for as long as the declaration of the national disaster persists or until they are withdrawn, whichever comes first. So it's important that one understands that these block exemptions are not intended to be blanket licenses to ignore competition law. Rather, they're intended to be a very temporary relaxation of certain competition laws for very specific circumstances. Both exemptions also require record keeping. So any healthcare or hotel companies who participate in agreements or practices falling within these exemptions must keep minutes of the meetings held and written records of their agreements and practices. And I think keeping a record of this, together with the stated justification for the conduct, will be helpful if there are ever any questions down the line. And that's it from me. I'm now going to hand over to my partner Albert, who will be taking us through two further block exemptions, namely for retail property and banking. And I think he'll also be giving us some practical guidance on tenders and biddings. Thank you.
Thank you, Susan. So I'll discuss 2 block exemptions, and I'm briefly going to mention some points on what we'll likely see, which is an increase in public procurement in the future. As Susan and Chris both mentioned, these block exemptions represent a first use of a very new power, and one can probably say that we were very lucky that these powers were passed so soon before this crisis hit us. And it's really been seen some quick action in the minister's use of these powers in publishing these block exemptions. So the block exemptions that I will deal with are the ones impacting on the banking sector and the retail property sector. And although 2 distinct sectors, I read them as coming from a very similar place. I mean, beyond only responding, of course, to the COVID-19 crisis, they seem to be borne out by the view that debt repayments and rentals are 2 of the most significant costs that many businesses face. And I read them as seeking to alleviate the burden that businesses will face by ensuring that A, cash flow is protected, and B, that credit extension can continue during this time. Obviously, if cash or credit dries up in a time like this, it can precipitate a decline in the economy of epic proportions. And I speculate that that's what's driving these block exemptions. So if we turn to the banking block exemption first, it really allows banks to coordinate on 2 aspects. The first aspect is infrastructure, and the second aspect is debtor and creditor management. To me, the coordination on infrastructure and infrastructure stability in particular is relatively uncontroversial, and I think it would be aimed at ensuring that there's cash available at ATMs, that the national payment system continues to work, and I think it would specifically cover things such as measures that we've seen where you can now withdraw from any ATM and not face a penalty charge for not using your bank's particular ATM. The second aspect, which really deals with debtor and creditor management, might be slightly more interesting to look at and might well be a bit more controversial. And it seems to me that, well, I mean, the block exemption specifically aims here to allow coordinated conduct in relation to the development of industry policies and monitoring in respect of payment holidays and debt relief, limitations on asset repossessions, and extension of further credit or credit lines to businesses and individuals who are facing financial stress. Now, one interpretation of the block exemption could be that it's primarily aimed at allowing the sharing of information and common reporting between competitors that might come with competition law risks in the ordinary course, with each bank left to craft its own response to the crisis in terms of products and how they engage with consumers. And I think that's been the case so far. So what I could see from the Banking Association's website and from what's reported in the media, what you find at the moment is that the coordination extends basically to saying that clients of banks should speak to their respective banks to find out what the options are for relief. And then on the face of it, there seem to be quite substantial concessions that are ready to be made by the banks individually. But I think that the block exemption can probably be read to lay the foundation for what is still to come in terms of relief packages from the banks. And I think one must bear in mind that these are exemptions. In other words, they must presuppose that an exemption presupposes a contravention, and therefore what you've seen so far to me would not clearly fall within the scope of potential contraventions of the Act, and that there must be something more that's anticipated to come out of these, the foundation that's being laid here. And it's also interesting to see that the regulations require the cooperation to be at the request and in coordination with the Minister of either the Department of Trade and Industry and Competition, or alternatively the Minister of Finance. Now, I saw yesterday, and I'm speculating now, that there was what one could probably call an emergency budget that was announced by the Minister of Finance, and in that document, the Minister of Finance refers specifically to relief measures currently under development, where retail banks would effectively be the conduits for products that would go to SMMEs in particular, in order to relieve them in this difficult time. And I wonder whether the real purpose of these regulations would not be to facilitate some additional uniformity in the type of products that one could see coming out of a relief package like that. And I guess we'll have to wait and see what happens in the next couple of days in terms of what additional economic relief is released by or is proposed by the government. And then just to briefly mention on the property block exemption, here it largely mirrors the banking block exemption, and it provides for coordination in respect of rental holidays or discounts on rental, eviction restrictions or limitations, which would be similar to, I would say, to your repossession limitations. And then it also provides for the suspension of restricted clauses, which may otherwise make it difficult for businesses to protect their viability in these times. That last one is not clear to me exactly what that means, but I think it's clear that the aim here is to try and alleviate the burden on businesses that have seen a complete shutdown in trade as a result of the lockdown in particular, and perhaps COVID-19 in general going forward, for as long as the state of disaster continues. Other than or in contrast to the banking block exemption, the property block exemption only applies to designated lines of trade. That would be clothing, footwear, and home textile retailers, personal care businesses such as hairdressers, beauticians, etc., and restaurants. Now, for me, the common theme across these lines is that these are very, very large employers and a big part of the service industry, which would be a very large and very deeply affected sector of the economy and a significant employer. What I find interesting here is that only retail property has been identified. To me, it seems that a big cost driver for many businesses would be the space that they occupy, and that would not necessarily always be retail space. So I'm not sure what the rationale behind that is. There is scope made for the expansion of the lines of the designated lines of trade that could benefit under certain of these concessions, but not necessarily for additional space to be identified. And it seems to me that the retail property owners are going to shoulder a big burden, and one that they're almost placed in a similar position to the banks on this. And I think that you've seen some relatively quick responses from the retail property sector, which I think is to be commended. But again, here, I think that we're at the start of a process. We're at the start of a new normal, and it might be that these are also laying the foundation for further relief measures based on specific interactions with the minister, as the block exemption anticipates. Finally, I just want to make one or two comments on what I think will be a feature going forward, and that is that you'll see that not only in South Africa but globally, that the state will become a big customer again in many sectors. And beyond healthcare, where Susan has dealt with the very specific interventions that we've seen, I think it's important to bear in mind that there are particular risks that come with participating in public procurement processes that flow from stimulus packages or times of national challenge, if you want to call it that. And if you think back to the 2010 World Cup, I think that You had an experience there where I think that both industry and the government felt that there were special circumstances meriting some form of cooperation between sector participants, which ultimately, when viewed in retrospect, resulted in collusion and investigations by the competition authorities. And I think that one must bear that experience in mind here. There's no reason to expect that the Commission will look any differently at collusive practices. And I think that one has to be particularly careful not to have your judgment clouded in a time of national challenge, to try and work on a collective response to the challenge, which might cross some lines in terms of how you interact with your fellow bidders and competitors in that process. So I think what's common and what's clear from all of the block exemptions is that discussions on pricing in particular remain very dangerous and remain topics that clearly should only be done either with an explicit mandate from your relevant government stakeholders, or should be avoided in toto in these circumstances. So, Chris, I'm happy to hand over to you.
Thank you very much, Albert. Thank you, Susan. So that really, I think, does sum up the steps that the Minister and the competition authorities have taken so far. They've identified some key industries where there needs to be a focus on trying to allow for some measure of coordination. I think the important thing to remember, as both Susan and Albert have pointed out, is that this is not an open sesame to full-blown collusion. Our competition authorities are very careful to make it very clear that the best way to come through any kind of financial crisis is for there to be robust competition. So this really is temporary only, and I think the one message that we'd like to just broadcast is that one still needs to think very carefully about the extent to which one does engage with one's competitors. There may now be slightly more room to coordinate on issues such as logistics, storage and warehousing, the shared use of certain assets, and even some exchange of information that ordinarily would cause competition lawyers to fall off their chair, particularly in terms of your stock levels, forecasts, etc. But all of those must be done with circumspection, and as usual with any kind of block exemption type scenario, one always look at whether there are less restrictive ways in which to achieve the same kind of efficiency. So certainly one has to do this with one's eyes sort of wide open. Maybe just to close off then, just with some thoughts from our side as to what a post-COVID-19 regulatory environment might look like. Now, it is always difficult to predict, and anybody with time on their hands would have seen there are various predictions around the world about what society is going to look like, what business is going to look like, and it's equally speculative to try and see where regulators are going to head. But I think there are some key themes that are emerging from what regulators around the world are doing that are just worth perhaps taking stock of. Generally, there is an intersection between competition law policy and competition law itself. And Eleanor Fox, who's a seasoned professor at New York University, has sometimes described these tensions between policy and law as really being amounting to sort of three what she calls inflection perspectives. I prefer to think of them as kind of points on a pendulum swing. And it's been pointed out that there are really sort of three constant areas of tension in competition law policy. The first is the notion that big business is always bad and needs to be hemmed in. The second line of thought is that laissez-faire economics is the way to go. A very light touch regulatory policy is the best way to drive innovation and best sort of allocative efficiencies. Then the third emerging sort of theme is one sort of which might be able to call sort of industrial policy, and this is the notion that the government should have an ascendant role in regularizing competition and market conduct. That can be quite good in certain circumstances where we see perhaps the government partnering more with big business or business in general in kind of a private-public partnership to try and address crises like COVID-19. But it also has a very bad side. This kind of industrial policy can lead very quickly to sort of central command type policy and centralization of a lot of aspects of the economy, which is something that we would want to obviously guard against. And I think what we can see perhaps emerging from the regulators' response to COVID-19, and perhaps more generally the state's response to COVID-19, has been to reach out more clearly to big businesses. In the competition field, it's dominant firms, but we've seen it with regard to the Solidarity Fund, the extent to which the government is really partnering with business in terms of trying to find the best solutions to the crisis. So perhaps one outcome of the current regulatory environment is perhaps a more lasting sense that the government has a bigger role to play in developing competition policy and industrial policy more vigorously. As I pointed out, that can be certainly a force for good, and it could lead to, I think, a more kind of cooperative relationship between government and business, but it can also lead to a pretty aloof state which prefers to run things centrally, and I think that's one thing we should arguably guard against. Something else that we anticipate might well emerge from the crisis is just an increased understanding from the Commission of how quickly cases can be run if necessary. We have a tribunal which is holding in camera Microsoft Teams hearings that are making decisions in chambers, and maybe some of that will survive in terms of a new dispensation where the Commission might be emboldened to act a lot quicker on certain abuses of dominance, which again might be a good thing. That is of course speculative, and there's always a danger that when the pressure is relieved, things become a lot slower, and of course there are options on the respondent side to slow things down, and perhaps if nothing else the tribunal will have a taste of how quickly it can run matters and how it can bypass attempts from respondents to delay matters, and we might see a bit more of a speedier route towards justice, which is something that I suppose many would welcome. What else do we see happening here and around the world? Obviously, with regard to the lockdowns that have been imposed throughout the planet, the data markets and digital markets really are coming into their own. So it's been something that regulators have been watching for quite some time. There's been tremendous concern about the growth of big data companies like Google and Facebook and Apple and the like, and there has been talk for a long time about the need to rein in some of these powerful forces. The difficulty regulators always face is a lack of evidence and a lack of a keen sense of exactly how powerful these sort of data-rich companies are, and I think we may find ourselves with a tremendous amount of evidence, real-world evidence, as to exactly how powerful the network effects, the access to data can be when pretty much the whole world moves on to digital platforms. And I think there'll be a lot more data to mine in terms of seeing the impact at a very granular level on all of our value chains, retail and the like. And I think that will give a lot of ammunition to regulators to perhaps more carefully think about the impact of big data and other sort of platform market effects on economies around the world. And finally, I think we will see perhaps an impetus for a lot of the work the Commission has been doing, both in data markets and certainly the timing for a lot of the work the Commission's done in terms of looking at data costs and efficiency in broadband is really timeous. Not deliberate, of course, but timeous. And so too, I think the work the Commission has done in the healthcare space, this really gives an opportunity for a real natural experiment to understand to what extent there may be space for cooperation between private and public healthcare and the like. And I think we're learning quite a lot about where the pinch points are in terms of healthcare. So I think that is probably an area where there is going to be a considerable amount of work being done in the future. So it'll be very interesting to see where we head in the future. Certainly, it's not going to be business as usual. Things will return to a semblance of normality. But I think that around the world, regulators have learned a lot. We do know that the regulators are in constant communication through the International Competition Network, which is an industry body, for lack of a better term, for competition regulators. And a lot of the dovetailing that regulators have done in terms of issuing directives and warnings and best practice notes in terms of how to deal with the crisis within a competitive milieu has certainly been coordinated between regulators, and I think we will see a lot more of that into the future. So certainly this crisis will provide a catalyst for hopefully more effective enforcement, but it's equally a risk that the government will see the scope to be far more centralist in its planning for the economy, and we'll have got a taste of that. So the hope is that the powers that be will very quickly revert to a more hands-off stance. And I must say, my own view is I think the minister has been quite circumspect in publishing its regulations. He's not usurped a tremendous amount of power. He's just put the tramlines in place for more effective crisis management during these very difficult times. So that is where we are, and hopefully it won't go much beyond that. I think we've taken up enough time. There's plenty to digest, and of course, as the lockdown lengthens, a lot of these issues that the regulations seek to provide for, which perhaps due to momentum and inertia going into lockdown, will now need to be addressed in the coming weeks and even post-lockdown in the coming months as our economy tries to make sense of where it is and where it's headed. And certainly you can expect our regulator to be very much involved in that, and you can expect us at Cliff Decker Hofmeyr also to be working with the regulator and the private sector to make sure that things improve for the better coming out of this. So it just leaves me then to say again, thank you very much to my colleagues Susan and Albert for helping out on this. For those of you who do manage to catch this, we will of course also broadcast it as a webcast. I understand there were some technical problems for some of you, and we do apologize for that. We will make this available, and of course please don't hesitate to get in touch with any specific questions that you have through the usual channels, and we can certainly help you navigate what might turn out to be quite a brave new world of competition law enforcement. Thank you very much.